Welcome, everyone. I'm Nancy Stek, the Associate Director of the New Jersey Lawyers Assistance Program. I'm particularly pleased to moderate the august group of panelists that we have today for the program entitled Report on the Recent Research and Progress to Improve Personal and Professional Well-Being for New Jersey Lawyers. Our speakers today will be Jeralyn Lawrence, President of the New Jersey State Bar Association and Managing Member and Founder of Lawrence Law; Robin Bogan, Co-Chair of Putting Lawyers First Task Force, Partner at Pallarino and Bogan; Bonnie Frost, Chair, Putting Lawyers First Ethics Arbitration Subcommittee, and Partner at Einhorn, Barbarito, Frost, and Botwinick; Matheu Nunn, Co-Chair, Putting Lawyers First Task Force, Partner at Einhorn, Barbarito, Frost, and Botwinick; and Maritza Rodriguez, Co-Chair of the New Jersey State Bar Association Wellbeing Committee, Co-Chair, Putting Lawyers First Mental Health Subcommittee, and sole proprietor of the Rodriguez Law Firm. For any of you who may not know us, New Jersey Lawyers Assistance Program has been providing free and confidential support and services to lawyers, judges, law students, and law graduates for almost 30 years, addressing the challenges and problems you will hear about shortly. We've helped thousands of lawyers, one at a time, and we'll continue to do that because that's the core of our mission. But without a way to change the culture and environment of the practice of law, we're swimming upstream. That's what's so exciting and important about the work of the Putting Lawyers First Task Force this past year and the plans they have for moving this critical work forward. This broadened view and approach can affect true change, meaningful systemic change to increase well-being in the profession as a whole. There's a lot of work to be done, and I know LAP is very excited about supporting those efforts however we can. After all, we're here to help. And we hope you'll join us in November when we celebrate our 30th anniversary. A reminder, you can put questions in the Q&A box as we go along, and we'll be answering them at the end. And I'm going to turn this over to Jeralyn Lawrence, who will be starting us off. Jeralyn.
Thank you. Thank you so much, Nancy. Thank you, Noreen. Thank you, Nicole. And I know Anna's out there somewhere, I hope, able to dial in as well. So really grateful for NJLAP giving us this opportunity during this very important well-being in the law week. And on the panel today are really the backbone of the Putting Lawyers First Task Force. There are many. There were 50 people plus that were on the task force. But who's on the screen today with Robin and Matt as co-chairs. Bonnie Frost and Jen Fortunato did so much on the ethics piece, as did Maritza and Amy Wexler. So it's really an exciting opportunity to be able to present with them today. So Putting Lawyers First was an intentional name. It was named because lawyers never put themselves first. The court comes first, clients come first, firm comes first, family comes first. So when thinking about what to name this presidential task force this year, just Putting Lawyers First is what struck the chord as to the name for our task force. And the genesis came from a quote by Desmond Tutu. And what he has said is we need to stop pulling people out of the river. We need to look upstream and find out why they are falling in. And that hit me particularly hard as you read the law journal or the newspaper or just talk to our colleagues about the stress and despair that they face on a daily basis in this practice of law. And we all love being lawyers. I mean, everyone on the screen does, almost everyone you talk to, they don't regret going to law school. They love being lawyers. I want my children to become lawyers. It's just a profession that's much harder than I ever anticipated. And I believe my colleagues would agree with that. There are plenty of programs that deal with mindfulness or other wellness initiatives that help deal with the stress and pressures of the practice, but we really wanted to focus on what was causing us to fall into this river of despair. So we formed 6 subcommittees through the Putting Lawyers First Task Force. The first one was the Fee Arbitration and Ethics Subcommittee. We had a Wellness Subcommittee, a Malpractice Subcommittee, a Solo Small Firm Subcommittee, an Online Review Committee, and being relieved as counsel, getting paid, helping lawyers get paid subcommittee. And those committees all worked independently with one common goal. What revisions, what changes could we recommend in the practice of law to put lawyers first, to make the practice of law easier? And we studied these issues for months, and the culmination of those efforts manifested in what is really a masterpiece of a report. The report is about 107 pages with exhibits and addendum and appendix. It's close to 500 pages. We have put together a redacted version of the report, a more manageable version of the report, which is 29 pages. I'd like to acknowledge Angela Stek for her hard work in getting that done, our executive director. That's the report that's on your website, that's on the State Bar website. And the feeling is that just may be a much more manageable report for everybody to read. Delving into the first and one of the biggest areas of the report is the Fee Arbitration and Ethics Subcommittee. And again, I would like to acknowledge Bonnie Frost and Jen Fortunato for all of their hard work on digging deep as to what's happening in those two systems. 75% of the attorneys that are disbarred are solo small firm members. And that's largely because they don't have accounting departments. They don't, that's not what they're doing on a daily basis. Larger firms, that's what they have. So solo small firm attorneys are trying to figure out how to practice law, but also be a business owner and make sure they're doing everything right. So we wanted to study what was happening, what was causing stress amongst our colleagues. Some of our recommendations in this part of the report include examining better ways for the ethics committees to weed out frivolous claims. Our number one request was to ask the Supreme Court to form a commission to study all of our recommendations and to collaborate with other stakeholders, the ethics folks, particularly as to how we can improve on things that are already working, because there certainly are things that work within the ethics and the fee arbitration system, but also identify areas of things that need to be changed. We wanted to create a better framework or pathway for cases to be disposed of quicker. So many of our colleagues talk about cases languishing or lingering in the process for years. So we want to study that. Many of our colleagues complained about the over prosecutorial nature of the ethics committees and how they are made to feel. So we've tried to address that in our report. Some of the number 1 and 2 takeaways that we want our colleagues to remember is, if you are ever the subject of a random audit or you ever receive a grievance, we strongly urge you to retain counsel. You must cooperate, of course, you cannot delay that cooperation, and you must cooperate fully, but please retain counsel. Part of our suggestions include asking the ethics folks to actually tell us that we have a right to counsel, and perhaps even secure a written waiver by us that we are waiving that right to counsel. Some of our colleagues have made admissions in that very first interview that ultimately led to their disbarment. This is what we are looking to avoid. They are prosecutors, the folks in the Office of Attorney Ethics, and they are not necessarily here to help you. They are here to prosecute you if you are doing something unethical. So please retain counsel, talk to counsel. Again, you must cooperate, but it's also very important to know what your rights are. We urge you all to continue volunteering on the ethics and fee arbitration committees. If you've already volunteered, please consider re-volunteering or upping for another term, or ask some of your colleagues or friends to volunteer. These are driven by attorney volunteers, and we need your help. These committees need lawyers to volunteer. One of our recommendations was, for example, I'm a divorce and family law attorney. If I'm going before a fee arb panel or faced by an ethics panel, we suggest that somebody with experience in family law should be on those panels, as they have familiarity with what life is like in our shoes. We also made recommendations with regard to statute of limitations. Right now, there is no statute of limitations. You can bring an ethics case against an attorney And one of our colleagues just finished up a suspension. She was suspended for 3 months from an ethics case that happened 17 years prior to the alleged grievance. So there is no statute of limitations, and there really is no standing requirement. Doesn't need to be your client that can file an ethics grievance against you. It can be somebody that overhears something that you said on a Friday night out with your friends at a bar. So look, we are a profession, and there is good and bad in everyone, and ours is not immune, but we just want a fair playing field, and that's what we've advocated for. Putting lawyers first also took a strong position, which ultimately led to the Board of Trustees of the State Bar taking a strong position on our Wade Committee. There's a Supreme Court committee which any day should be releasing a report where we, the State Bar Association, is championing hard a path back for lawyers who have been disbarred. And we want a path back for lawyers who have been disbarred regardless, not just Wilson violations, which is a financial violation, but any violation. We want to join the 41 other states in our country that have a path back. It's not an easy path back, deservedly so, but we are championing for a path back, so stay tuned for that. So really proud of all of the hard work that went into that subcommittee, and we will continue trying to advocate for the formation of a commission so that we can continue studying these recommendations and moving them into the stage of implementation. Next, I want to talk about the Health and Wellness Subcommittee, which again was led brilliantly by Maritza Rodriguez on your screen and Amy Wexler. When I talk to you about passion and commitment to something, Maritza and Amy, just like Bonnie and Jen and Matt and Robin, really are just a personification of that, and so grateful to them and their efforts. Maritza and Amy identified a professor out in Utah by the name of Matheu. Matheu has conducted wellness surveys for other bar associations, so they identified him as a resource. We brought that to Angela Shack and Sharon Balsamo and the leadership staff at the State Bar, and garnered their approval of us to hire Matt to help us develop a survey. And with Matt, Maritza, and Amy Wexler's expertise, we developed 90 questions that we sent out to our members, law schools, and other agencies, entities that had a lawyer involvement, and asked them to answer our survey of 90 questions. There was 1,637 lawyers that responded to the survey. And what we found is shocking and alarming. We've confirmed that we are a profession in crisis, and we have confirmed that the pace of our practice is not sustainable and something has to give. What we found as a result of the response to the survey is that our burnout level is nearly 2 times as high as any other working population. 49% of the lawyers that responded to our survey describe feeling burned out. 23% of us reported being depressed. We reported a high percentage of depressive symptoms. We are 2.5 times higher than other working populations. We are 2.5 to 3 times higher than any other working population of having suicidal ideations. Sadly and shockingly, 10% of us who responded to this question of having suicidal ideations or thoughts of self-harm in the 2 weeks prior to them answering that question. 52% of us feel bad about ourselves or feel as if we have let ourselves or our families down. 56% of us have misused alcohol. We are 4 times higher than a reported sample of full-time workers to misuse alcohol. 14% of us abuse drugs. Drug abuse is 1.5 times higher than comparative published data. 28% of us consider leaving the profession. 68% of us have felt anxiety in the last 2 weeks. That is 5 times higher than most recent data on other workforces. The California Lawyers Association and the DC Bar also got together and they conducted their own survey. And what they shared is lawyers with high stress levels. And again, when I talk about this. I don't know any other lawyer. I don't think there's lawyers that have low stress levels. I think we all are operating at a high stress level. But lawyers with high stress levels are 22 times more likely to contemplate suicide than those with low stress. On aggregate, 8.5% of lawyers reported suicidal thoughts compared to 4.2% of the US population over age 18 or over. Again, in New Jersey, we are at 10%. So something has to give here. This is really shocking results that have been confirmed by the survey. What we've learned and what we've identified in our report, factors that contribute to burnout. Lawyers describe a lack of boundaries. They never have downtime. They never have time off. 74% of the respondents indicate they work on weekends. 51% indicate their employers expect them to be available outside of normal business hours, either frequently or always. 29% stated these expectations interfere with their personal lives frequently or always. Lawyers indicate that lawyers who work 7 or more hours on the weekend per month are 6 times as likely to report burnout. Lawyers who worked an average of 15 to 20 additional hours outside of normal business hours during the week were 8 times as likely to report burnout. So we're extremely focused on burnout and lawyers wanting to leave the profession, and of course, thoughts of self-harm and suicidal ideation. The report talks about the role of the judiciary and how they can help us. 51% would like the court to continue virtual court appearances post-COVID. 48% would like the court to consider granting timely adjournments requests more liberally. So there's a whole section in the report that deals with how the judiciary can help us. A call to action. The report contains a quote from the Colorado Supreme Court that we think really sums up what we're trying to do here extremely well. Anyone who practices law knows that life in this profession is stressful. Let's face it, billable hours, client demands, deadlines, long hours, and pervasive conflict make our jobs hard. The same work ethic that enabled us to survive law school and weather the bar exam can cause us to drive ourselves into the ground, particularly when the culture of our profession tends to reward and glorify workaholism and demand perfection. The stresses of the profession are taking a toll on our well-being. Left unaddressed, that toll has consequences for us, our clients, our communities, and the future of our profession. Thankfully, one of our main requests of the Wellness Subcommittee was to ask the Chief Justice to form a task force, a committee to help study some of the recommendations and develop new ones. And we are proud to report that yesterday, Chief Justice Rabner rolled out a Supreme Court committee that the chief has formed. He has appointed Justice Solomon as the chair of the committee. I'm pleased to report that Robin Bogan and myself will serve on that committee, and Maritza will serve as the delegate of the Hispanic Bar Association. But we are really excited about the hard work that is about to continue in that committee. I know that the court has the Putting Lawyers First Task Force report. I'm sure Justice Solomon will read that. If not, Robin, Maritza, and I will certainly talk about it in our role in that committee, but we look forward to that hard work. Another extremely important announcement with regard to the committee, and again, with tons of thanks and praise and appreciation to Angela Stek for her due diligence and spending a lot of time in vetting mental health counselors. One of the recommendations of Putting Lawyers First was to outsource with third-party therapy entities. Maritza and Amy Wexler spent a lot of time talking to a company Unmind and Tava Health. Angela as well spent a lot of time talking to them. Angela also spent a tremendous amount of time talking to a company, CNA. And the Board of Trustees has approved, as of our last meeting, that we will work with. The contract is being negotiated. We have not signed anything, but we do have board approval. We will certainly be rolling this out in full strength at the annual meeting. Tim McGoffin, our incoming president, will make sure that there's an announcement at our 100 seminars, I believe, that will be happening in May, talking about this new program. But it's very clear, this report makes very clear, Angela has been working with the chief on this in years past and has vetted these entities as well. But it is very clear that mental health is a priority for the New Jersey State Bar Association, and we need access to quality mental health care. So what we are going to do is enter into a contract, and as a member benefit, our attorneys are going to be able to have three free sessions, say that a couple times fast, with the mental health provider for free. That would be part of your member benefit. As soon as you make that appointment, all efforts are going to be made to make sure that the therapist that is treating you is in your insurance. And if you do not have insurance, they have committed to us that they will work with you on a sliding scale. So probably the most consequential benefit ever to come out of the State Bar Association. Really thrilled with regard to that development. Just before we signed on today, Maritza shared with me that out of Utah, can you just jump in, Maritza, and just share with us the statistic that you shared with me? Did you tell me 1,200 people?
Yes, that a program similar that was put in place in Utah using an app instead of an actual provider. They rolled it out, a similar initiative, and within the first 50 days, 1,200 psychotherapy sessions were scheduled. So it's been incredibly successful. I can only imagine how successful it'll be in New Jersey. So this is awesome.
Yeah, so this is not, Maritza and Amy vetted that program, as did Angela Stek, but we did not go with that program, although it sounds wonderful. We went with the program where it's not going to be app-based. You're gonna have a human being, you're gonna have a therapist, a counselor that you can either meet in person or online. So really proud of that program. So stay tuned for more details as we roll that out. Another initiative that the Wellness Subcommittee really championed was asking for the Supreme Court to eliminate question 12B from the character and fitness examination. And in doing so, we collaborated with Rutgers Law School and Seton Hall Law School. Both law schools sent us letters asking to join our voice in asking for the elimination of that question. The presidents of the student union of Rutgers also sent us a resolution asking that they join the chorus as well. And our concern there is question 12B on the character and fitness examination focuses on conditions and impairments instead of focusing on conduct. And what so many of our colleagues have told us and remember from their law school days, and it's even happening today, law students are not getting the mental health help that they need because they are afraid they need to disclose that help on their questionnaire. So this question is really a barrier. It's an impediment to people getting therapy and help. So the State Bar Association has sent a letter to the chief asking that he eliminate this question. We sent, along with our letter, the letters from Seton Hall and Rutgers Law Schools, as well as their student unions. So stay tuned for that. I want to share with you that our advocacy on putting lawyers first in its entirety, as well as our request to eliminate 12B, has received not only statewide coverage, but national coverage as well. It's been covered in Reuters, the ABA Law Journal, and so it's really garnered a lot of attention. And what makes us really proud about that is hopefully it effectuates change. The Putting Lawyers First Task Force also offered recommendations on our other various subcommittees. We're still studying and reviewing recommendations with regard to online reviews. One of the ideas was asking that the rules of professional conduct be changed as it pertains to online reviews. So many of us right now depend on online resources for our business. And right now we are really handcuffed if somebody submits a negative defamatory online review against us. We're pretty limited as to how we can respond. So we are considering how we can approach that. The Board of Trustees is still under consideration as to how we're going to handle that. What Putting Lawyers First has recommended is that if somebody puts a negative defamatory online review up about you, that be deemed a controversy and that you have more flexibility as to how you can respond to that. Our solo small firms section subcommittee also has wonderful recommendations with regard to succession planning, temporary disability status, developing contingency plans. So please take a look at that. And they largely build on a task force that President John Keefe formed, Lawyers Helping Lawyers, when he was president of the association. So we've encompassed a lot of his report in our work as well. We have recommendations as to how to help lawyers get paid and how to help us be relieved as counsel, because sometimes we get stuck into a case and the court does not let us out, and we don't find that to be extremely fair. So we'd like to recommend some changes to the court rules in that regard. So when all is said and done, we are here for you. This was a report about you. It was about lawyers putting yourselves first. You can't lead if you're not well. You cannot practice if you are not well. And life is just not manageable if you're not well. So hopefully these recommendations, I think they're close to 200, hit near and dear to your heart. Please read them. Please send us any feedback, any suggestions, thoughts. We're here to help you. So that's Putting Lawyers First. Thank you so much for your time. Again, thank you to everyone on the screen and everyone on the Putting Lawyers First task force for changing the way we do business and your brilliance and that masterful report. And I'm going to turn it over to Bonnie Frost. You have to go on mute, go off mute. Yeah. Thank you, Bonnie.
Okay. Well, thank you, Jeralyn. And all I can say listening to you, I personally, it's very inspiring. And what's inspiring to me is that I remember when we first started having these meetings, I was so impressed with your vision. And it was so all-encompassing. And I just felt there was a part of me that said, you know, too long, we've been just sitting and just going along and not really paying attention to some of these issues. And so I think that every lawyer in the state of New Jersey owes you a great debt for that vision. My part of the presentation will be somewhat brief, but I can tell you that the statistics that Maritza's group has brought to the fore are really sobering, obviously, to say the least. And our task force dealt with not only an assessment of the procedure in the ethics and fee systems, but I wanted to share with you how that does intersect with mental health, addiction, and how, for example, the Lawyer's Assistance Program can be of great value. An attorney's behavior outside of his lawyer life, her lawyer life, can be a cause for discipline. I'm going to share with you two different cases, and they have two different results, in a sense. But the first one is about an attorney named Milena Miladinovich, I think. She was arrested for committing some driving offenses, failing to drive in the right lane, not obeying a stop sign, as well as DWI, where she had 0.362 as her reading, which is quite amazing. But an offense, or one might think DWI might be cause for discipline, but it is not. But if something happens as a result of someone being under the influence of alcohol or drugs, then that offense can be a cause for discipline. What she also did as part of her alcoholism, and eventually we find out from her mental health issues, she engaged in a series of terroristic threats against her therapist. They were also anti-Semitic. She left voicemails on her psychiatrist's hotline, the personal line, the business line, sent texts. And finally, she revealed that she had mental health problems. She had anxiety, depression, bipolar disorder, PTSD, and intermittent explosive disorder. She sought treatment. This was sort of a coming, she realized that she definitely needed more help than what she was getting. She began treating with medication and psychotherapy. And because that she had some criminal charges that related to her behavior, she was under the supervision of the Philadelphia District Attorney's Office. She acknowledged her mental health issues and that they played a role in her criminal convictions. She was suspended in New Jersey. She was suspended in Pennsylvania. And as part of reciprocal discipline, she was suspended in New Jersey for 3 months. But before she was able to return to the practice of law, she had to provide proof of fitness and enrollment in an Office of Attorney Ethics approved alcohol treatment program. And she had to supply proof that she had attended this program for 2 years. So here's the Supreme Court putting conditions in order to not only help the attorney, but also to protect the public. And some may think that this attorney should have been maybe more severely punished, but I think this goes to show that the court is concerned about lawyers who have mental health problems, and they want to positively help them address them because they do want them to get treatment. In contrast, I want to share with you a case called In re Filomeno. This was a gentleman who was part of a large investigation of illegal narcotics activity in one of our larger northern counties. And he was charged criminally with a count of possession of cocaine and possession of drug paraphernalia. 2 months later, he was again arrested, charged with conspiracy to possess cocaine. He was admitted into PTI, and he had to submit to random drug testing, and he had to complete the lawyer's assistance program. So the court, again, even though it's a trial level, intervened and said, you must go to get help from the lawyer's assistance program. And so what happened with this gentleman, normally when you are arrested for possession, a small amount of drugs, it's a 3-month suspension, and that's just what it is out of the gate. But this gentleman, this is what they said, acted expeditiously to address his criminal charges. He submitted immediately to drug rehabilitation. He reported to counseling offered by NJLAP program, and he attended, and this is what's significant, 415 meetings, 243 meetings of Alcohol Anonymous, 108 meetings with NJLAP, 34 individual counseling sessions, as well as random drug testing. And that's the way he came before the Disciplinary Review Board. And because the Disciplinary Review Board, for the most part, has to rely on precedent, which was 3 months, that was what they recommended, the board recommended. But they did acknowledge his extraordinary efforts to rehabilitation. So the Supreme Court, however, said, we're not going to suspend this gentleman because a suspension would serve no purpose but to undermine extraordinary steps toward rehabilitation. So I think that what's important about this, the court recognized certainly what he was doing. He had a need, but back to the New Jersey LAP program, that it really is an extraordinary service to our attorneys. They have individual counseling, and Nancy can say more about that. They have individual counseling, they have group counseling. They will help you they will help get you in touch with someone who can help you and what you especially need. So it's not only addiction, it's not only alcohol, but it's mental health as well. And it's an extraordinary asset to all of us lawyers in New Jersey. And so Jeralyn took certainly part of what I was going to say about what's important, what we found was important that came out of the studies. And one of them was that there needs to be better screening to weed out frivolous grievances at the outset. And part of this is a difficult, maybe, let me back up, maybe we need to change the standard that is utilized when the secretary, for example, at the local level gets a copy of the grievance, because the secretary says, well, I don't think this grievance is really an ethics violation, because sometimes, having been a secretary for 15 years, we would get people, they were really complaining about their bill. They didn't like the bill, so they thought they'd file an ethics grievance. But the secretary has to make a decision. Is this really ethical behavior, unethical behavior? Or is this something that there's something else going on? And when the secretary makes that determination, the layperson on the local committee comes in and makes the decision. But the important thing is, when you get the envelope from either the Office of Attorney Ethics or the local committee, it will strike fear in your hearts. You will be very anxious. I think anybody would be thinking, oh my heavens, am I going to lose my livelihood? Well, that's probably not going to be the case, because even in, I'll give you a statistic, even in 2021, and we don't really have the full statistics for 2022 yet, but 768 grievances were filed and only 124 were disciplined, and that wasn't all disbarment. So you're probably not going to, lose your livelihood. But for those of us, and I'd say 99.9% of us, we have pride in what we do. We love what we do, as Jeralyn said, and this is the last thing we want to have in our mailbox, whether it's by email, it's not by email, you'll get a hard copy. So it's important, as Jeralyn noted, get your own attorney right away and make sure you are truthful and listen to what your attorney says, because that attorney, just like when we have clients who come to us and we say, look, when you come to us, you're handing over some of your anxiety and your concerns, put them on our shoulders, which is why we have some mental health problems, but we're the ones, you're paying us. We're going to take some of that anxiety away from you. We're going to help you. That's what a lawyer is going to do for you. So I echo what Jeralyn says, because I think that's really important. I think all of us, we all have egos. We all think we're doing great. And we say, oh, I can talk to them. I can say this to them. And many times that's just not the right thing to do. But I don't know, Matt might want to ring in, because I don't want to take over. He and I talked about some things to talk about, so I don't want to take over what he might want to say.
No, so just to back up in terms of what this group did, we sent out a survey. Just under 200 attorneys responded. These were attorneys who were either involved in the system, meaning they had ethics complaints brought against them, or were individuals that represented attorneys. In addition, we made efforts to contact the 17 ethics secretaries and 16 fee arbitration secretaries. Unfortunately, we learned that after we made overtures to these groups of people, the certain individuals at OAE put the kibosh on that and directed those individuals not to speak to us. So we only received feedback from 9 of the ethics secretaries and 5 of the fee arbitration secretaries. And again, we wanted this to be a robust report and not go into it with, an agenda of any groups. So we asked the OAE at the director level and a couple other individuals with executive level positions there to participate, and we did not receive any response. So that sort of ties in perhaps to some of the comments that we received from the attorneys involved in the process. As Jeralyn mentioned, there seemed to be, and again, these weren't necessarily the findings of the PLF Task Force, but these are comments from people who were involved. There was an overemphasis on prosecution. And, for those of you, and I used to be a prosecutor, we were always told it was about doing justice and doing the right thing, and maybe not perhaps taking the most draconian methods to achieve justice. There was a notion among many of the commenters that it almost seemed like OAE was out to get them. And if the complaint was about one issue, OAE, the investigation would go well beyond the face of the complaint. And so I just say that to you in terms of, if you get nothing else from this today, if you get one of those very vague letters, you have no idea what's about to happen to you, get an attorney, because the ethics process could weave its way into something that perhaps you didn't anticipate. Some of the recommendations that we made, and we made 17 of them, and they had some parts to them, but diversion. Bonnie could tell us a lot about the diversion program, but one exists and many people don't know about it. So one of our recommendations was, when that initial letter goes out, there should be a reference that there is something called diversion and you might be eligible for it. And the problem right now is once the investigation is complete and the complaint is filed, you're no longer eligible for diversion. So one of our recommendations was that diversion should be available at any point in the process, and that perhaps we should expand the type of alleged ethics violations that would warrant diversion. I look at it as like a PTI type of thing for those of you who do criminal. It's a way to make sure that you address the concerns, but don't necessarily have a permanent ethics violation against you. The biggest issue, the thing that we received many comments on, was the timing of things. And Jeralyn mentioned this at the outset, but there's a court rule that sets aspirational timeframes. It's Rule 1:20-8. The timeframes are six to 9 months, 9 months for more complex matters. But what we heard from people, one of the attorneys we spoke to represented 3 people. 19 months, 20 months, 21 months, these investigations were ongoing. Another attorney told us that when he called the OAE, the response he received was, I don't know, it could take 8 weeks or it could take 16 months. So when you hear from Robin and Maritza in a moment, and you hear about the mental health issues amongst one of them being anxiety of our colleagues, imagine the level of anxiety you have when you are running a business, you have clients, maybe you litigate cases, you're trying cases, and you have this ethics thing looming over your head, and you're in the abyss with no guidance as to when it's going to be completed. So, one of our recommendations was that there needs to be something more than these aspirational timeframes. And look, one of the issues is getting volunteers. And Bonnie and I spoke about this before today's seminar. If you want to get involved, and maybe you don't like to lecture, or maybe you don't want to be, involved in leadership in the NJSBA or be a trustee, you can volunteer and participate in the ethics process. And that perhaps might be the best way to help the public and attorneys, because you can assist with the process and perhaps help weed out frivolous complaints, and or take care of the public by making sure that legitimate complaints are properly prosecuted. We only have, I believe, 18 minutes left. So I'm going to, unless Bonnie has anything else today, I think we should turn it over to the Mental Health Task Force, because what you're about to hear it was staggering to me when I heard it and read some of these statistics as this was all unfolding. And I think, if for nothing else, for those of you who practice and are listening, I don't mean to sound cliche, but I'm going to say it. You're not alone with whether it's depression or anxiety or feelings of isolation or burnout. You're about to hear how our colleagues are dealing with the profession. Thank you.
Thanks, Matt. I'll jump in at this point, and then Robin will follow up after me. But Jeralyn, thanks for giving such an incredible overview of the 300 pages. It's very impressive every time I hear it. And I forget about some of those stats, because I think that we lived them for so long that we internalize them. And it's indicative of our profession, correct? Because as lawyers, we function in environments that are incredibly competitive, urgent, impatient, achievement-oriented, high stress, and we're perfectionists. We set these incredibly high expectations for ourselves, and we ignore the physical and emotional signs. Like, we normalize working in incredibly abnormal working environments to continue to function and meet these deadlines that we impose on ourselves, and that are sometimes imposed on us by those we work for. And the culture doesn't help, right? The clients are always in crisis. Their needs come first. The work expectations are high, expectations for billing. Mistakes, as we've learned, can be incredibly costly, right? They can cost us our own license. And the trauma that our clients, especially those in areas of criminal law, or family law, or in cases where adult child protective services are involved, those clients who are experiencing trauma, we, the attorneys servicing those clients, often internalize that trauma and relive it, vicariously as well. And so we carry these things around with us, and then we don't take the time to take care of ourselves, right? So well-being is not limited to the absence of illness. And, when we say that we're talking about well-being, we're not saying that you're happy all the time. We're just saying that you've got some balance in areas that you are neglecting very, very much. And there are, why should we care about well-being in our profession? Well, there's 3 good reasons, right? One is because it's the human thing to do. These are our colleagues. This is the profession that we're in. And we want everyone in this profession to be healthy and to be good. 2, it's the competency case, right? We want to make sure that if we're okay, we can represent our clients and avoid disciplinary actions. And we can be diligent about our representation to clients. And 3, there's the business case, right? If the first 2 don't move you, at least the business one should, because when you've got healthy employees, you also have, and they're healthy, they're happy working, they can be more productive. So, I won't go into the 3. I know there are 3, one of the stats that sticks out for me is that 39% of the lawyers did not feel comfortable taking time off to address, well-being. And so this spills into that they are 10 times as likely to be burnt out, to feel burnt out. It trickles into depression. It trickles into suicide ideation. Our solo practitioners are also a population that, as Jeralyn mentioned in the beginning, they were the ones that were the highest and most likely to be disbarred. So solo practitioners, it's an isolating profession, and we need a lot more support. And I'm looking forward to the task force and the recommendations that'll come for that for solo practitioners, and as well young lawyers who are particularly anxious and particularly overwhelmed. And we're one of the groups that we did find some really startling statistics about that concerned us. But, this is a great start, Jeralyn. I mean, you set out from your swearing in, and it's kind of, amazing timing with only 2 weeks left that this much has gotten done. So kudos to you. And the work is only going to start, right? It's going to be a few more years, and I can only imagine the change that we can do. Robin?
So I'm batting cleanup. It's really been an interesting journey to spearhead this project with Matt Nunn and with Jeralyn and with Maritza and Bonnie. And it's interesting when you know that there are certain things going on in your profession, but you don't really have the data. And what was really fascinating about this process was the fact that we found various mechanisms, and we developed those mechanisms to gather that data in an anonymous way, so that it's true and it's raw and it's real and it's what our colleagues are feeling. I know that what you've heard a lot today can seem a little depressing, right? The reality of 50% of us feel isolated, 50% of us feel depressed, 50% of us, feel this way or that. But I'm actually optimistic. I'm optimistic because this is the beginning of a culture shift, a nationwide culture shift that's going to take place in New Jersey. And I'm excited for when this data comes out 5 years from now, after these initiatives have been implemented. The way that I look at it is similar to Michael Phelps, 28 Olympic gold medals, and starts talking about his battle with anxiety and depression and suicidal thoughts. And you have other professional athletes that start to talk about this over the last 10 to 20 years, to the point where it's now a normal discussion. It's normal. It's just that it hasn't been part of our discussion because we're attorneys, and it's a culture shift, and the culture shift has to start with us. because nobody else is going to do it. And now we have the data. So even though the people on this screen, to a certain degree, even though they may not admit it, feel like they are kind of at the end of something, we are really at the very beginning of something. We are at the beginning of a call to action, which is supported by data, which is supported by the data that we've gathered. And now there are recommendations for change. And it is about, it's now incredibly important for us to take these recommendations and to actually move forward and do something about it. So that's why I feel great about it. I'm excited to see what direction this heads in. And I think, look, if you have the opportunity to look at the report, I'm not saying you have to read the whole thing. Just a couple of the highlights you may want to look at. There's in the big report, I don't remember what page, this is how crazy it is. It's on like page 16 of the big report, I think. There's a chart. And that chart captures all of the correlations between various statistics, the significance of various correlations. And when you look at that chart and it just has all these connections and has a tremendous amount of information. The report that we issued, we only had a very limited amount of time to dig into that data. That data is like a treasure trove of information. Now I sound like a real statistical geek. But the reality is that someone who had the time and energy to really, dive deep into that information, there's a lot of information there that can be utilized to move us forward. So, I mean, that's really all that I wanted to highlight, was that this was really a call to action for all of us, and I'm very excited for the direction. And it's interesting. I think and Jeralyn, maybe you want to comment on this a little bit. You had a certain vision of, you knew certain things were not going the way that they were supposed to go, and you knew certain things needed to be fixed. But I would think that even some of the results and the things that we found even surprised you. I mean, I would think that some of the information that we gathered, that even you learned something from this whole process, and the different information that we gathered along the way.
For sure. I mean, so my installation speech, I knew the statistics. I didn't know they were going to bear out in New Jersey the way that they did as to anxiety and depression. I think what hit me the hardest was the suicide and thoughts of self-harm or wanting to leave the profession. I mean, we all, have those fleeting thoughts, but the fact that that was out there, the feeling burned out, to me, I heard a saying, effort is required, exhaustion is optional. And I think so many of us just walk around in a state of exhaustion because that's what we've been raised to believe the life of a lawyer is. And we really are not good at setting boundaries, and we never say no. And to talk to our colleagues about them all feeling the same way, it was extremely eye-opening for me. So certainly learned a lot. Learned a lot about 12B, that character and fitness issue, and got really excited about trying to be the advocate to get that done. Have the association put its weight behind that. So everything's a learning curve, certainly every day. I mean, I think sometimes we should bill by decisions we make instead of by the hour, because we're learning and growing every day. But it was eye-opening, but as you said, Rob, this started with a vision, with just knowing, in my gut and talking to all you guys growing up in the law, that lawyers were not getting a fair shake in a lot of ways. And we just want to be treated fairly and have a fair seat at the table. And as you said, I think the report gives us a lot of ammunition to do just that.
Matt, was there something along this journey that struck you in terms of you got to see many elements of the report and work very closely with Bonnie on the ethics piece? Was there anything that struck you that was either surprising or something different?
I don't know that I appreciated the amount of our colleagues. And look, we all at some level have situational anxiety or situational depression, or, something's going on in a case you're stressed out about, but this went far beyond that. The amount of our colleagues who are suffering with deep depression, anxiety, substance abuse, but also feeling like they don't want to get the help that they need because either of the cost of mental health care or they don't want to appear vulnerable. And it's 2023. I think we've moved a little bit away from being shameful about dealing with these issues, but that was the third highest cited reason for not getting mental health by people who believed they needed mental health treatment, was they didn't want to seem vulnerable. And I think we need to get past that. You mentioned Michael Phelps. He's been open about it. A lot of actors and actresses have been open about mental health. But we as attorneys, we're out there fighting the fight for people. We don't want to appear vulnerable. I don't know that I appreciated how much our colleagues are struggling with it. So I just say, keep that in the back of your mind when an attorney is asking for an adjournment or you're busting their chops about something. There's a fine line between advocating and being a jerk. And sometimes I've stepped over that line myself. I think if you really read this report, Jeralyn's laughing because I may have done it with her in the past. But just be cognizant of that you're walking a tightrope there, and you may not realize that in the case of Smith versus Smith, you're giving your adversary a difficult time, but your adversary might really be having a difficult time in other aspects of life.
Mm-hmm.
But that's the point. The change starts with us. And right. And so no one's coming to help us. So we have to help ourselves. You have to be a good colleague, as Matt just said, and as you highlighted as well, Robin. So we have to be the change. Somebody put in the chat, how do we get away from these standards that are just unattainable, or why are we always the butt of lawyer jokes? So, we have to be the examples, of leadership, of kindness, of compassion, of treating people the way we want to be treated, and holding this profession that we all love in very high esteem, and not tolerating the lawyer jokes. They're not funny. We're out there volunteering the most, doing the most. So take them seriously, but I think just be the example and treat people the way you want to be treated.
Which I think is also why you're pushing so hard for 12B, the removal of 12B on the character and fitness application, which is the application you need to fill out in order to be licensed in this state, right? Because it starts at the student level, right? We can't have these conversations about, hey, get help. But then on the other hand, tell our students, hey, you can't get help, or if you do, it might jam you up and you might not be able to, become a lawyer. So it has to be universal. It has to be okay at all levels. And we have to be talking about it openly and supporting them, which, I teach at the law school and I see it every semester. So it's incredibly, my students are incredibly anxious, and they've been, I've tried to set up an open space, but that's only one class. We're talking about students at all the law schools across the country, even in New Jersey, in both the law schools. There are 3 of them, sorry.
Maritza, it's funny because I'm thinking back to a year ago where this all started, and you came up to me in Atlantic City and you said, we have to do something about 12B. And I'm like, 12 what? Like, and literally, it's not that I didn't know about it in law school. It didn't have a number associated with it. We were just told to lie. That was the message. Whether it applied to you, didn't apply to you, it was basically, that was kind of the message, was just don't go down that road. And that's just not the message that, and I didn't even think anything about it until we dove into it, and it makes perfect sense. And I'm so happy that steps are being made to eliminate it. Bonnie, did you have any closing remarks that you'd like to make? You're muted.
I know.
Okay, sorry, just want to let you know.
I just wanted to follow up on, in terms of the ethics piece, I wanted to follow up on what Matt said about diversion. I really hope that the opportunity to be offered that opportunity, that option, PTI, but it's only for minor misconduct, but it shouldn't be cut off from that. I mean, that would be a really big help to lawyers. I think some people get jammed up and then they end up getting an admonition or a reprimand when they really probably don't even deserve it, just because of the cutoff date. And I think that's a big help. That would be a great big help.
Mm-hmm.
We are at 2:02. Are we supposed to end at 2?
Yes, I'm just wondering if there's anybody with any final comments.
We have we have an additional CLE coming up at the State Bar Conference on Wednesday. And Jeralyn will be leading this conversation again, having it again, but also just leading the discussion. And it's definitely relates to a lot of these question and answers, which I'm going through right now, about the culture shift, about the expectations, the data, and how do we move forward from this. So I invite you to definitely join us in Atlantic City Wednesday. I believe it's in the afternoon. You can make it.
Thank you.
Other people are asking if this was recorded. Nancy, I think you said this is recorded. Was
It's
this seminar recorded?
It'll be up on YouTube. You can get
Oh,
that.
we're going to be YouTube famous.
You're going to be YouTube famous. You can go through the New Jersey Lawyers Assistance NJLAP.org website and find your way to the YouTube channel. Noreen, if you have other directions that would be more helpful, please, you can put them in the chat box. And it takes us usually about an hour or so to get it up there. So, but it'll be available sometime today. And then forever and ever, amen.
Great. Well, thank you. Thank you, Bonnie. Thank you, Maritza. Thank you, Robin. Thank you, Matt. This has been quite the journey, and couldn't have asked better human beings to be on this ride with. So thank you. And thank you for having us today. And for the attendees out there, thank you for joining. Have a great day.
Thank you for the work that you're doing. Bye-bye, everybody.